Hello, everybody. The Targeted Justice v. Garland podcast is back, and we have a very important issue about a lawsuit number 2. Yes, Targeted Justice has filed another lawsuit, and you will be amazed what kind of lawsuit this is. I can't wait to discuss it with my co-pilot and my co-host Anna Toledo. I want to say something that for the last 4 weeks I was feeling very much under targeting, and I want to thank everybody for their prayers, emails, words of encouragement. But my best support body during this period was my dear friend Anna Toledo, and I am thankful for your support, Anna. Please say hi to our audience.
Hi, everyone, and hi, Len. Thank you. It's my honor and it's my pleasure because I have told you many times, and I will not tire saying you are my hero because I know how you push past your pain to continue this crusade to end the torture for more than 6 million people around the world.
Yes, it's more important than anything than any of us or anything that we do personally. It's a team effort, and we cannot do it without you. We cannot do it without Richard. And I guess we cannot do it without me. I feel like a part of the team. I found my home at Targeted Justice, and we are walking the walk. We're doing things. We have filed this incredibly important lawsuit, and let's start the presentation so we can finally talk about it. Lawsuit number 2, Targeted Justice v. FBI. So this is a lawsuit about a FOIA request. The first lawsuit was filed in January of 2023. This lawsuit was filed on March 1st of 2024. It was filed in the United States District Court for the Southern District Court of Texas, and these are all the section of this lawsuit, and we will spend some more time on some sections and less time on other section. The main part is the complaint and introduction and the explanation what kind of violation FBI is conducting. Let's go right to it. This is an action under the Freedom of Information Act, also called FOIA, for injunctive and other appropriate relief. Plaintiff, Targeted Justice, seeks the immediate processing and timely release of agency records from defendant, which is Federal Bureau of Investigation, FBI. On September 16, 2003, the president signed Homeland Security Presidential Directive 6. We talked about it in depth, so I'm just going to skip this information. This is an introductory information. The FBI is the agency in charge of maintaining the list through its interagency outfit known as the Terrorist Screening Center. The TSDB, the Terrorist Screening Database, contains at least 4 categories. 2 of these are known as handling codes 1 and 2 and are supposed to contain the records of those known or suspected to be engaged in terrorist activity. These categories that contain the records of known and suspected terrorists, or KST, together are what is colloquially referred to as watch list. Anna, feel free to interrupt me and add some important information to this narration.
Well, we're just this is the introduction, and it's just putting in context the request, the FOIA request that was made and rejected by the FBI. I wanted to put the court in the position to understand the importance of the request. Freedom of Information Act is a statute that was enacted to allow citizens, not just journalists, because targeted justice is considered a media organization, but not just media organizations, but average citizens to have access to see how the government conducts its business. And the way that they are handling FOIA right now, it's not how it's supposed to be.
Continuing the introduction, the FBI places on TSDB individuals that do not meet the reasonable suspicion terrorist criteria and do not represent a threat to national security. These individuals are added to the TSDB handling codes 3 and 4 under secret criteria. And we have a testimony of Mr. Robinson, who is currently a director of Terrorist Screening Center. In black and white, he said, we put terrorists, but we also put individuals and American citizens using secret criteria. We couldn't believe that declaration of Mr. Robinson, and yet here we are, secret criteria.
Yeah, it's the FBI arrogance that they can do whatever they can, that they're above the law. Just this past week, you had journalists indicted, on absurd charges when 60 other journalists were covering J6, and this is exactly the same thing. No, we do it because we can. We put American citizens on a terrorist list under secret criteria, even though they're not terrorists, just because we can. Who is going to tell us not to do it? And that's why, we have a right as a media organization to supervise, scrutinize the activities of the government.
Yes, I call it improvisation. Here's the executive order that establishes TSDB, and then after that, FBI just starts adding codes and criteria. It just improvises with it like it's playing a jazz piece. But there's no improvisation when it comes to executive orders or congressional law. But that's exactly how they treat it. So they put these people who do not represent a threat to national security under codes 3 and 4. And because they are not a terrorist threat, they do not undergo additional screening when traveling. The FBI places the individuals that do not meet terrorist criteria within the subcategories of the TSDB known as handling codes 3 and 4.
And I didn't make this up. This comes from audit reports. Okay. So it's for those targeted individuals out there that say there is no such thing, this information targeted justice didn't make up. It comes from official Office of the Inspector General audit reports of the Terrorist Screening Center.
But how does the FBI treat this information?
Well, they say it's sensitive. It's not classified because, as you well know, they distributed through the National Crime Information Center to 18,000 law enforcement, to over 532 corporations, and 1,440 organizations. I assume those numbers have gone up because these are the numbers since 2019, obtained in the El Haiti versus Cable discovery. However, and also distributed to 60 countries. So wherever you go, the label of suspected terrorists follows these people that comprise 97% of the terrorist screening database. What's incredible is 97% of the terrorist list is composed of people that do not meet the terrorist criteria.
So, individuals in handling codes 3 and 4 have never been arrested, indicted, tried, or convicted of a terrorist offense. Very important phrase that was central in case Kovac v. Ray. The watch list does not include records from the TSDB handling codes 3 and 4, only those from handling codes 1 and 2. This is an important distinction. What is a watch list and how do they relate to the handling codes? It sounds so artificial. It's really structured the way that makes everyone confused. I don't think that the people in Congress really understand the difference between these handling codes and the watch list. And so we must educate them. And this lawsuit is a part of that education. And even more so, United States Department of Justice, Office of the Inspector General, in their 2005 audit, concluded that the records in handling codes 3 and 4 comprise 97 of the TSDB. And I couldn't resist using this slide prepared by Mr. Lighthouse when he used it at recent symposium on target. The only information I added here is this little rectangle. So category 3 and category 4, aware targeted individuals and unaware targeted individuals, they comprised 97 of TSDB is non-investigative subject. Same thing, 97% of TSDB. This gives you a structure. This gives you the inner workings of this complicated categorization. And this is how I think they've been able to hide this important information. Numbers 11, 12, and 13. The audit report, this is 2008, a defendant did not remove records from the TSDB in a timely manner. Then in the 2009 audit report, once again, the agency did not timely remove records from the TSDB as required by agency regulations. So looks like they conduct these audit reports year after year after year, and the FBI does not comply with the requirements of the audit reports. In light of uncontroverted DOJ report regarding agency negligence and mishandling of TSDB records listed above, Targeted Justice served a FOIA request on defendant FBI requesting the records of deceased individual removed from the TSDB handling codes 3 and 4 subcategories. That is a move that nobody expected. I don't know where the idea came from. It didn't come from me. I think it came from Richard Lighthouse and you. And I'm just observing this legal maneuvering. Nobody expected that somebody would go and request handling categories 3 and 4, but not who are in those categories, because the government response is always, we cannot confirm or deny, but we asked for deceased individuals, and that is a game changer. After having exhausted the administrative remedies ensuing FBI's denial of targeted justice FOIA request through the timely filing of an appeal, targeted justice now moves to the court. Let's go through the exhibit because they are a part of the lawsuit. They go in the chronological order. So the first FOIA request by targeted justice was served on October 31st, 2023. On November 6th, the FBI denied the request. I want to point out that October 31st, 2023 is the end of the year. Targeted Justice v. Garland was filed in January of 2023. This FOIA request was filed at the end of the year. And on November 6th, the FBI, of course, denied the request. Then on January 31st, 2024 and 2024. So please excuse my typo. This is 2024. TJ filed an appeal and FBI again denied the request. This is this year. And then on February 13, just less than a month ago, the Office of Information Policy of the United States Department of Justice acknowledged the FOIA appeal. And on the same day, the OIP, the Office of Information Policy, issued a ruling denying the appeal and confirming defendant's denial of the records request. And once again, on the same day, the OIP also denied as moot the request for expedited appeal. So here's the timeline. Do you have any comments about this timeline? It looks like February 13, they produced 3 documents that in their mind was supposed to close this issue entirely.
Exactly. Yeah, they just confirmed it. Uh, they didn't discuss the reasons why, they denied specifically, all the arguments that were brought on appeal. And again, I have to emphasize that I think that this whole process of basically requiring a normal person to almost have the expertise of an attorney to carry out a FOIA process, it just doesn't sound to me legal, because the purpose of it is for an average person to be able to do a request and obtain the information without having to enter into these like sophisticated legal arguments. But that's just my opinion, and that, we will see, because that's one of the things that we are presenting to the court. That the arguments raised to deny the request require legal expertise, and that's not the intent of the statute.
I agree. You actually detailed in a section called the FBI's response and arguments on appeal and boilerplate denials. These are some of the arguments that you presented. The first one was totally new to me. FBI did not produce Vaughan index. I'd never heard of Vaughan index. A Vaughan index is a document that agencies produce to justify each withholding of information under FOIA exemption. So they have to justify, they have to list the reason for denial for each request. They didn't do that. Why didn't they do it? It's a mystery to me. Are they just disregarding the law, or they're kind of showing disrespect to the court, or they are disrespecting the plaintiff? Which one of these theories do you think is most plausible?
Well, the Vaughan index refers to a precedent set by the courts where it says if you agency are going to deny documents requested, you have to make an index, basically to put a court or not only the requester but also a reviewing court in a position to determine if the denial was appropriate or not. So it's a case that Vaughan was a plaintiff in that case, and that's what it's called. It's a Vaughan index. It's a a list, an index of the documents that are responsive to the request, but that are being withheld, and then they say the exceptions. So they never, and I haven't, lately, they're not even doing that. They're not even complying with that. So they're pretty much disregarding the obligation that has been imposed by courts to produce that index.
You know what it tells me? It tells me that they feel that they are above the courts. That's what
That
it communicates to me.
Yeah, well, look, so many people have been denied, even the fact that, you were given what, 4 documents in your Privacy Act request. Mine was sent back in November of 2022, and to this day they have not replied to it because, of course, they're afraid of, they don't know what to give. But it's just that's not how the law is supposed to operate. They are literally, it's pretty much catch me if you can. That's the attitude. In this case, they were quick. This is the first time they responded in a record time. The law gives them 20 days to respond. They responded in 6 days, denying the reply because it was like, no, absolutely not. We're not going to give you anything.
Yes, you further say that FBI set forth grounds and exceptions, but none of these exceptions are applicable or valid or legitimate and violate FOIA. And instead, FBI produced a GLOMO response. GLOMO response is when they neither confirm nor deny whether a particular person is in a particular watch list. That's a GLOMO response. But the FOIA that Targeted Justice filed did not ask for the records on the watch list. These people do not form a watch list. They're off watch list. So the argument doesn't apply.
Well, to me, it's gaslighting. It's like, yeah, you asked me for watch list records and I don't have to give them to you. And that's not. First of all, handling codes 3 and 4, admitted by the FBI, are not watch list records. Second of all, are the records of people that have passed away. So, no, we did not ask for any records of any person that is in any particular watch list.
Okay.
Let me add here that the audit
Okay.
reports that you mentioned before are the last ones available. I also made a FOIA request for all the most recent ones for the past, since 2009, because for some reason, unbeknownst to us, they're no longer available on the internet, and you have to make a FOIA request to get them. So we did ask for them to get the audit reports from 2009 to the present, and that's another FOIA that is pending. And of course, if we don't get it on time, we will file another lawsuit because we have a right to see those audit reports. Those are public documents.
This is simply incredible. There's so many violations on top of violations. Let's move further. The FBI GLOMO response invoked Privacy Act exemption. However, protection of the privacy right of individual who may be on the watch list for a limited time and later removed. That's the Privacy Act exemption. Does that make sense?
Yeah, but no, it makes no sense because we didn't ask for any records from the watch list.
Okay. Then the next point is very, very interesting. The practice that FBI carries out is such that it habitually releases to the public record of deceased people on handling code 1 and 2. And you gave 4 examples from Colorado, Brooklyn, in mass shooter cases. It was released, and it was released for categories 1 and 2. So if you release it for categories 1 and 2, why for deceased people? What's the objection for releasing category 3 and 4?
Yeah, it's called they cannot go against their own acts. They are stopped from claiming something in one situation and then claiming something else in another situation. So aside from the fact that we didn't ask for watch list records of deceased people, they have a tradition of publicly disclosing if a mass shooter kills himself or is killed by police. They say, oh yeah, he was on the watch list. Not on handling codes 3 and 4. He was on the watch list. So, they cannot use it to deny them because they have publicly, voluntarily disclosed information about deceased people without worrying about their privacy rights.
And the next one is one of my favorites. FBI said that they cannot legally object to the privacy rights of deceased individual. Really? Because privacy right cease to exist once the person is deceased. How do you square this circle?
Yeah, and the proof of it is you have, for example, records of Martin Luther King, deceased presidents. I mean, there's just so many released records of people that have passed away that it's not, you know, even in defamation cases, privacy, the Supreme Court has recognized that, it pretty much dies with a person. Your privacy rights exist while you're alive.
Yeah.
When you're dead, they cease to exist.
The intelligence record exception is inapplicable. That's the argument that the FBI makes. But the handling code 3 and 4 do not meet reasonable suspicion and not screen as such. So there's a mismatch. Oh, we can't do it because it's intelligence, but 3 and 4 are not terrorists. So what kind of intelligence are you talking about? Big mismatch. How do you explain it?
And not only that, but also that under Eric Holder, he established in a memorandum the procedure when invoking intelligence, the exception of intelligence records. They have to provide a sworn statement and convince the court that, in fact, it's a matter that is covered by intelligence, classified. So that's really not applicable in this case, because as they have admitted, handling codes in 3 and 4 do not represent a threat to national security.
And you end this section with the statement that the none of the exceptions invoked by the FBI serve to prevent the production of records. And you gave 14 reasons. And I couldn't possibly put them all in the presentation, but there are 14 of them. Give us, and all of them are like little golden nuggets. So which golden nuggets are your favorite?
Well, the most important one is the mischaracterization of what we asked for. They're saying we cannot give you records of people on the watch list. We didn't ask for that. We asked for records that have been removed because of for reason of that the person has passed away. So it's like, no, I'm not going to give you this because you asked me for this. No, I didn't ask for this. I asked for this other thing. So that's what, it's just very telling, because they couldn't find a reason to deny it, to deny what we asked for. So they just mischaracterized what we asked for and then said, okay, and this is why I'm going to deny it. And so that's just plain wrong. And also, I think that this gives the court the opportunity to say to the agency, you have to stop this practice of denying things, because public has a right to scrutinize the work or lack thereof that the agencies do. There has to be transparency. So that's what we're fighting for. We want to make the FBI accountable and adhere to their regulations and expose whatever irregularities there are. We're going to continue exposing them. We have, 20 pending FOIAs, and we're not going to stop.
No, we won't. And you end your complaint with a prayer for relief, and you ask for defendants to find defendants withholding to be improper. You ask to order to conduct a thorough search for all responsible records, and you ask to order to immediately process and release all the records. Basically, none of your exceptions invoked work, applicable, legitimate. So, FBI, get to work, produce the records ASAP. And I could not agree more. So that's the lawsuit in a nutshell. And as you can see from this last slide, this is my personal favorite argument that people have no expectations of privacy. To me, if I had to like single out just the one argument, that would be my favorite. That's the one I would put on the t-shirt
It
and
makes
parade
sense. It makes, for
around.
example, when you're see a trial, for example, and then there's a pathologist talking about the autopsy report. Yeah, and this person had this drug and this other drug and this. So you see that that barrier of what at some point could have been, a drug testing that is confidential, private, and no, you have no access to it. Well, it's out in the public when the person dies, because the privacy, it's a right that is inherent to life. And so when you are alleging it on behalf of a third party, the person has to be alive. No, I cannot give you those tax records because it's their private thing. But in this situation, that doesn't apply. And so let's see, we have to, I already requested the summons. We have to serve them and continue the process. But next month we're going to be doing something new, and we're not going to stop. I just want people to know that even though this has been a very slow process, we already have been for over a year since the filing of TJV Garland, and we are now waiting for an announcement of the date on the oral argument. That doesn't mean we have not stopped working every day at Targeted Justice. At least I tell you, I work every 7 days a week, and so does Richard, to end this atrocious program. We're always constantly obsessed with what are we going to do next. So just rest assured that we hear and we know about your pain, and it's what continues to inspire us to continue the fight.
Well, this is all that we want to communicate to you about this new lawsuit filed by Targeted Justice on March 1st. So I am curious to ask you the following questions. Well, first of all, if the records are released, in your estimate, how many names would you think it contains? It's 2024, and it's been 21 years since the inception of TSDB. How many people would be on this deceased list? Just throw me a number. I'm just curious.
I can't I can't I have no idea. I really don't have any idea, because it's got to be probably, I mean, I don't know, it's probably over 10,000, but I don't know. I can't imagine how many are there. I have no idea. That's why we're asking for it, because we
We're
really have.
asking. My guess,
Uh-huh.
which I pull out of thin air, was 20,000.
It's gonna be interesting to find out,
Yeah.
because as you see, the Office of Inspector General, they were very clear and reiterated it in at least 2 audit reports. You are not removing the names when you have to remove them. So, and we're not even asking for people that were removed because they decided, okay, I'm not gonna maintain you here. It's just people that you had to remove because they're not living anymore.
Do you expect there will be a significant number of names on that list of people who committed suicide or people who committed mass shooting?
Well, the mass probably, yes, both probably, and they better not, alter the information produced, because then that is another crime. That is a crime. So yeah, I expect that there's gonna be there people, definitely. Probably the mass shooters are gonna be there,
Uh-huh.
and also a lot of people that committed suicide. Yeah, definitely.
One more question. This list, if we obtain it, will open a door to a whole new series of investigations by the families of people who were in the handling categories 3 and 4. Wouldn't you agree with that? And maybe what other kinds of lawsuits we can expect?
Well, what I really want is to expose the agency negligence and, and take it to Congress and have Congress do what they have to do. They have to put some controls on this agency that is out of control. It's completely unhinged. And now that we know that the Peters Committee is looking into their conduct through the report mislabeled as a threat, and then the other 20 senators that are looking into it, I want to be able to bring this to Congress and say, here, this, you could have subpoenaed this information. You didn't do it. I am, doing this work for you. And please now do something about this, because this agency is out of control and completely unhinged. And it's only doing it to continue justifying bigger budgets. It's completely unnecessary and abusive. It's an abuse of agency discretion. So it is my hope that we can bring to Congress the evidence to curtail the powers of the FBI that have gone, uncontrolled for so long.
Yes. So these are all the questions I have for you, Anna. So please give us your final thoughts. Share maybe some insights. I guarantee thousands of viewers hold their breath to know what's on your mind these days.
Well, it's people, can't understand how it is to do the work I do, because I wake up in the morning, I go to sleep, just, my mind is only thinking about this all the time. When I'm not insulting the criminals that do the things they do to us. Uh, but we're always creating, and we're always looking for new opportunities to bring this down as soon as possible. And I think you can agree with me that the term targeting is no longer, it is starting, even though we're still very shadow banned, it's starting to be recognized. And just like I have said before, don't make it about yourself. Please share, particularly the video we did last Sunday about the killed children and the V2K. Please share it with everybody you can. Go to our Rumble channel, Real Targeted Justice, and share that content, because it is being built as a tool, as an information library, a tool for all of you, and for non-targeted individuals to understand the atrocities that are being carried out by our own government. Thank you.
So as an observation, I think this lawsuit is the cleverest FOIA request. And this lawsuit that the FBI will have a hard time to defend. They are already contradicting themselves in the current line of defense argumentation. I call it an explosive lawsuit. It's filed by Target Justice with superb and very sophisticated thinking by Richard Lighthouse and UN Toledo. I have nothing to do with this lawsuit except for pure admiration. We know this is a marathon, not a sprint, but please understand the significance of this lawsuit. It will propel the issue of targeted individuals forward by many miles. Well, this is it for this episode. I hope you have been informed about this new case and now you understand its importance. I can't wait to hear what happens next. Among daily torture, unbearable misery, and inhumane neurological enslavement, we targeted individuals now have something else positive to look forward to. So stay emotionally strong, keep up good spirit, power through unjust suffering, reject surrender. And I will be doing the same thing alongside you, bringing light to the very complicated issues the best way I can, with realism and hope. My TI brothers and sisters, until next time.